Okay. Well, welcome everybody. Just had to wait a couple of minutes to ensure that we had the live streaming on, because we're live streaming tonight for those people that actually can't get here. So thank you for coming along and taking the time to attend this presentation. I think most of you know me, but for those who don't, my name's Michelle Leclerc, and I'm President of Employment and Social Security. And I'm joined today by Deputy Yerby, who will be presenting to you. And then we've got our other two committee members, Deputy Shane Longley and Deputy John Gollop, who will be available to take questions after the presentation. So this is a really, really important week for us. We launched our public consultation last week, and the purpose of tonight is to take you through the presentation and the key aspects of our proposals. We are keen to hear your views, and that's what this is about. It's consultation at this stage. It's not bringing the policy paper yet. So the Disability and Inclusion Strategy was approved by the states in November 2013, and responsibility for the strategy was transferred to the Employment and Social Security Committee in May 2016. And we've come a long way putting these draft proposals together, and we believe they're essential to tackle discrimination in Guernsey. But we also feel that they're proportionate. And it's no longer a question of whether we need discrimination legislation, but what form it should take and how it should be implemented. So before I go any further, I've just got a few housekeeping points. If you can ensure your mobile phones are turned off, and I've made sure that I have, and if Deputy Gollop, have you got yours turned off? I don't believe there are any fire alarms planned for this evening, but if the fire alarm does go off, please exit via the main doors to the right and to the left. And just to let you know that we are live streaming, and when we come to questions, we'll be taking hopefully some questions from online as well as from the audience. And I think we'll go on and make a start on the presentation. Okay, so as I said, 2016, the States of Guernsey Policy and Resource Plan identified a strategic commitment to one community, inclusive and committed to social justice. And the Disability and Inclusion Strategy is one of the priorities in the Policy and Resource Plan. And as part of the Disability and Inclusion Strategy, the states agreed that detailed policy proposals should be developed for the introduction of disability discrimination legislation. But when ESS began the work, and having looked at model legislation, we felt that rather than developing a series of laws, first disability, then age, then race, and so on, we felt it would be better to address multiple grounds at once, and it would ultimately be more efficient and create a fairer and more consistent approach to non-discrimination. So in June 2018, just over a year ago, the states unanimously agreed that the scope of this project should be increased, and we should develop proposals for new legislation to protect people on multiple grounds. The aim of the legislation is to promote and protect people's rights to non-discrimination, equality of status, opportunity and treatment. And we think that more equal opportunities will enable people to achieve their potential and will lead to a more inclusive society. It will also be good for the island's reputation and, we believe, for the economy. Non-discrimination is a cross-cutting theme in human rights law, and some of the human rights treaties which have been extended to Guernsey, for example the UN's International Covenant on Civil and Political Rights, require states to introduce legislation to prohibit discrimination. As well as helping us to comply with conventions, we have signed up to having legislation in place that will also help us to seek the extension of other conventions which the states have agreed to. These include the UN Convention on the Elimination of All Forms of Discrimination Against Women, otherwise known as CEDAW, and the UN Convention on the Rights of Persons with Disabilities. So we've been on a journey. We've worked with consultants from Ireland looking at model legislation and have had discussions over the last 18 months with groups that represent people who will be affected by the legislation. And I see some of those people are here tonight, and I thank you for coming along and giving support. Both business representatives and groups that represent people who have a particular interest in the protected grounds. Once the consultation is completed, the team will analyse the results. During this time, a business case for an equality and rights organisation or an ERO will also be prepared. The feedback from the consultation will feed into final proposals to be submitted to the states for debate no later than April 2020, and that's along with the business case for the ERO. If the states agree the proposals, then we'll move into phase 2 of the project. And phase 2 is that means that the legislation will be drafted. If approved, the policy letter will be legislative drafting instructions for the state's legal draftsmen. We've developed our policy proposals in a high level of detail to remove ambiguity and help expedite the legal drafting process. We know that this is a big change for many, and training and information will be provided to businesses and the public during this time. We will also look at ensuring we have the structures we need to provide advice, hear complaints and so on. And I would like to emphasise that it is our aim for an ERO to be set up prior to legislation coming into force and subject, of course, to the necessary funding being approved. Phase 3 will be the approval of the legislation by the states, and we estimate the timeline on that is likely to be no earlier than 2021. So when the new legislation comes into force, we do intend to repeal the existing sex discrimination ordinance, as sex discrimination will be prohibited in the new legislation. So if we have an overview of the draft proposals. So there are some new aspects in the draft legislation that we want to bring to your attention. Firstly, the proposals go beyond the field of employment and cover service providers as well, including education, accommodation, clubs and associations and the public sector. There will be more protected grounds that will allow more people to register a complaint if they feel they've been discriminated against. There will be some provisions which aren't in our existing legislation, such as harassment, equal pay, appropriate adjustments, and an anticipatory accessibility duty. But Deputy Yerby will explain these more later on in the presentation. There will also be a new structure for the awards and remedies, and the tribunal can order if they find that discrimination has happened. So we're not just looking at financial compensation. Presently, a discrimination complaint can only be made on the grounds of sex, gender reassignment and marriage. However, the new proposals will allow people to register a complaint on the basis of those shown on this slide. And for those people at home that may not be able to see the slide, I will read them out. So on the basis of carer status, disability, marital status, pregnancy or maternity status, race, religious belief, sexual orientation and trans status. And these are what we mean and refer to as the grounds of protection. Some of these characteristics apply to everyone in Guernsey. For example, everyone has an age and a nationality, and anyone could be discriminated against. So the legislation will protect and apply to everyone. The fields cover when someone will be protected. People will be protected from discrimination when applying for a job, at work, in contexts related to work. So, for example, apprenticeships, vocational training, employment agencies, company directors and partners in firms, trade unions and so on. As a consumer, when accessing goods or services, so when you're shopping, banking or socialising at the pub or eating at a restaurant. In education, when using public services, when buying, leasing or renting a property, both commercial and residential, or when joining or being a member of a club or association. As mentioned previously, there are a number of specific questions that we would like to receive feedback on. The first is the definition of disability, as we are proposing a broad definition similar to that used in Ireland and Australia. We would also like to hear the public's views on when children and young people should be protected from age discrimination. So we know that there are good reasons why you might treat a 6-year-old differently from a 16-year-old, whether that's in school or in terms of what they're allowed to buy in the shops or what games they can play or films they can see. We don't want the discrimination law to prevent different treatment when it's in the child's best interests, so we are proposing some restrictions on age-related discrimination. But to be clear, children will always be protected from other kinds of discrimination, such as race or disability. Our question is simply about when children are treated differently because of how old they are. And thirdly, we are proposing that landlords will only be able to specify no children in certain limited circumstances, which is a departure from the present practice, and this is a key question we would welcome feedback on. Further questions include whether sex should be defined biologically, based on gender identity, or being defined as a man or a woman, and on what basis trans people should have access to single-sex spaces or services. But we'll highlight some more questions later in the presentation. Now, Deputy Yerby will take you through some of the key elements of the proposals. Thank you, Deputy Yerby.
Sorry, I'm just going to have to move the staging block slightly to one side. There we are. When I hand back to Mish, she's going to touch on how the law is enforced. But just to put it in context from the start, I think it would help to be absolutely clear that the committee has consistently tried to ensure that breaches of non-discrimination law will be dealt with as civil offences, not as criminal offences. We can't see how getting a criminal record would help to achieve the fundamental purpose of the law, which is about changing behaviours and attitudes and building a more inclusive community. So I think it's really clear, just to be helpful, that that is the context which we're talking in. So the next few slides are just a whistle-stop tour of some of the key concepts in our proposals. The first, of course, is direct discrimination. So when you're introducing a law, it's important to be really clear about what types of behaviour you're trying to prevent. And the types of discrimination that we are prescribing are fairly standard in non-discrimination laws around the world. So direct discrimination is treating someone differently precisely because of a protected characteristic. So, for example, if an employer refused someone an interview just because their name didn't sound British, that would be direct discrimination on the basis of race. There are, of course, reasons why you might treat a person differently which have nothing to do with the protected characteristics, and we are not trying to impose some kind of cookie-cutter equal treatment on every human interaction. So, it would still be perfectly legitimate to hire somebody who is more qualified over somebody who is less qualified. That's a reason for different treatment that isn't based on any of the protected grounds. And also, we'll come on to the question of exceptions in a bit. We recognise that sometimes there are legitimate policy reasons to be treating people differently, even when a protected ground is engaged. The concept of discrimination by association is also in our proposals. And if you think here, for example, about a child where a nursery refuses to enrol a child because his mums are gay. Now, their sexuality is nothing to do with him, but he has been discriminated against, denied a service by association with it. And that is, again, something we think it's important that the law should prevent. Indirect discrimination, again, it's common in non-discrimination laws, but it's a more complex concept to get your head around. So I'm going to try and walk through this one with a bit of an example. So indirect discrimination is where you have a rule or a policy or a practice which at face value treats everyone the same. It applies equally to everyone, but it has the effect of disadvantaging a certain group of people more than other people because there's something about the rule and the way in which it interacts with that group that affects them particularly. So if you imagine, for example, if an airline advertises for people who are below a certain height for cabin crew, now, in practice, this might disadvantage men's access to employment more than it disadvantages women, because as a group, men on average are taller than women, so more of them are going to fall foul of the height rule. So arguably, this is indirect sex discrimination. It's indirect because it's a rule that applies equally to everyone, but in practice it affects the employment prospects of one group of people much more than it does another group. So if there was no good reason to have a rule like that, you would expect that the airline would need to get rid of it. But there's also this concept of objective justification within non-discrimination laws and within our proposals. And the idea behind objective justification is that sometimes you have rules like this for good reasons. So the airline might have a legitimate aim. They might be trying to protect the health and safety of their workforce. You know, if you're going up and down the aircraft cabin and you're having to stoop every time you go up and down, that's not going to be good for your employees' backs. So the airline's legitimate aim might be to try and protect the health and safety, the well-being of their employees. So that would be part of a test as to whether the rule could be objectively justified. But the airline would then have to demonstrate that the rule they have in place is the best way of achieving that aim. So do they have a legitimate aim? And is this the best way of achieving it? Is it proportionate? Is it appropriate in the circumstances? If they can clear those two tests, then they can still have practices which might unfairly disadvantage one group, which might disadvantage one group more than another, but for which there are genuine reasons. So this concept of objective justification applies in the case of indirect discrimination, but you'll also see as you look through our proposals that we're suggesting it can apply to direct age discrimination, that it can apply to discrimination arising from disability, which I'll come to in a moment. And it's also used in the concept of genuine and determining occupational requirements. Sorry, that's a bit of a mouthful, but the idea is that sometimes an employer might need to employ a person with a particular characteristic to do a role, so say a man or a woman or a person with or without a disability, if that characteristic is intrinsic to the way that the role is done. And you might think about things like intimate personal care. If the characteristic really is intrinsic to the role, then you can class it as a genuine determining occupational requirement, and that means that it's legitimate for employers to recruit to it in that way. So as I said, discrimination arising from disability is really a belt and braces protection to make sure that the law really is effective in offering disabled people the protection that we want it to. So if you think, for example, about a person with a guide dog being denied access to a taxi, what you don't want is the driver to be able to turn around and say, well, it's got nothing to do with their disability, it's because of the dog, you know, I just don't allow dogs in my taxi. The guide dog is only there because the person has a visual impairment. So the circumstances which result in them being denied access arise from disability, and so does the discrimination. But as with indirect discrimination, it would be possible for the taxi driver to refuse if they could objectively justify doing so. So if you imagine a situation in which, say, the taxi driver is allergic to dogs, so there's a reason why he might not be able to, or she might not be able to have dogs in the taxi. And then finally, there is denial of an appropriate adjustment. So both discrimination arising from disability and denial of an appropriate adjustment are new concepts for Guernsey, because, as you know, we don't have any protection on the basis of disability at the moment. I'm going to unpack the general concept of appropriate adjustments in a moment, but just to say at this point, this kind of discrimination will apply if you've got a situation where it's clear that a person needs an adjustment, where it's clear that the organisation, so the employer or service provider who's responsible for providing it, is able to do so, and where they still refuse to do so. So if all those criteria are fulfilled and there's a refusal to provide that accommodation, then that will also be classed as a type of discrimination. Now, there is already a protection against harassment law in Guernsey, and that covers situations that cause distress or fear of violence in any sphere of life. That is a criminal law, and it is separate to what we're proposing here. But we are proposing that harassment or sexual harassment on any of the protected grounds, so the characteristics like age, disability, sex, etc., which Mish outlined, will be prohibited at work and in the provision of goods and services, so in the areas where this law operates. And you can see how that's consistent with the aim of this law, because what we want is for this law to ensure that people can access employment and can access goods and services, can access the life of the community on a fair basis. And harassment operates to create a hostile or degrading environment at work or when you're trying to access a service. And it's just as sure as discrimination to prevent people from accessing work or preventing from accessing goods and services. And then, of course, there's victimisation. Again, this is fairly standard in non-discrimination laws. And in the concept of non-discrimination laws, it means something quite specific. So For example, if I have complained about discrimination at work, whether that's complaining about being discriminated against or helping a colleague to make a discrimination complaint, you as my employer can't then turn around and treat me worse because of it. Or similarly, you know, if I'm a customer and you as a service provider decide to treat me differently because I've complained about discriminatory treatment, that's not okay, that's victimisation. And laws, non-discrimination laws tend to look particularly harshly on victimisation because it can have the effect of undermining the whole law. So, you know, if you have reason to fear that you're going to be treated worse because you have dared to make a complaint, then it guts the effectiveness of the law as a tool for creating a fair playing field. So we will have a provision in the law that prevents victimisation. But as I said, there will be exceptions carved out in the law. So again, fairly common in non-discrimination laws around the world. Exceptions provide for circumstances where it's legitimate to treat people differently, even based on the protected grounds. So, for example, it wouldn't be unlawful discrimination to target public health screening services where we know they will have most benefit. So, for example, offering breast screening only to women and only to women within a certain age band. And we're also suggesting it wouldn't be unlawful, for example, to offer concessionary fares to families or to older people, or to organise competitions along the lines of gender or nationality or age. So the example on the slides, you could still have a Guernsey men's under-21 football team. So one of the key questions for our consultation is whether we have got this exceptions list right. There are hard copies of the exceptions list to take away if you haven't already had a chance to look at it. You can also look at it online. We have organised it in two different ways. We've organised it by sector, so employers and service providers and so on. And we have also organised it by protected grounds, so things like sex and disability and so on. And that's so that you can quickly find the exceptions that you think are most relevant to you if you don't want to have to leaf through all the exceptions to try and work out what's going on. So we've consulted extensively, particularly with other states committees, to try and make sure that we have identified pretty much all the circumstances where there is a legitimate policy reason why you might want to have an exception. So we think our list is pretty comprehensive. But getting the exceptions right really is one of the most important things. So we're really keen to get feedback. We want to know if you agree that the exceptions are right, if you think that there's anything that we've missed that ought to be included, or if you think that there's anything that we've included that actually really ought to be left out. And at this stage, I think it would be helpful to point out that there is a general exception which says that anything done in accordance with another law isn't going to count as discrimination. So if you take, for example, something that's done in accordance with GDPR, with data protection law, even if that disadvantages one group of people more than any other, it isn't going to be unlawful in the context of this law. But having said that, in the context of looking through Guernsey's legal framework and putting together this list of exceptions, we have identified some very outdated pieces of law. So, for example, Guernsey introduced same-sex marriage in 2015, but our registration of births law still doesn't allow for same-sex parents. So when we go back to the states with our final proposals, we are going to include recommendations that some of those outdated laws should be prioritised for review as soon as possible after this. So those are really the core concepts around which our non-discrimination proposals are based. But I just need to spend a bit of time on the concepts of appropriate adjustment and accessibility, because these are the provisions that could really lead to positive change for disabled people in particular. So they really give effect to the law when it comes to disability. And I think you will have heard of appropriate adjustments or reasonable adjustments before. So the idea here is that sometimes it is necessary to treat disabled people differently from other people in order for them to have equal opportunities and to be included. And this can be achieved by making adjustments in the workplaces or to the way that services are provided. Now, the important idea behind appropriate adjustment is that it has to meet two basic tests. So the first and probably most important is that it has to be appropriate to the disabled person's needs. So if you've got an employee with a visual impairment and they rely on a screen reader or large print documents, then you can't just think, oh, I know how I'm going to make my workplace accessible. I'm going to offer them copies of all our important documents in Braille. Well, the person doesn't read Braille, so it's not going to work. You need to have an adjustment that is appropriate to the needs of the individual in front of you. But the other test when it comes to appropriate adjustments is that they mustn't pose a disproportionate burden to the employer or service provider who is responsible for providing them. So if an adjustment isn't practically possible, it's not physically doable, or if it isn't affordable, bearing in mind the size and resources of the organisation, then they're not going to be expected to provide it under the law. So you can imagine that what a larger employer or a larger service provider might have to do in one context is different to what a smaller employer or service provider might have to do in the same context. But as I said before, if you've got a situation where you've identified that an appropriate adjustment is needed, you've identified that the organisation can provide it, and they still refuse to do so, that will count as a form of discrimination. So as you probably gathered, appropriate adjustments are most useful in the workplace or in other situations where there's a specific disabled person who will be disadvantaged unless an adjustment is made to ensure they're included. But if you think about shops or restaurants or other service providers or even schools, then you've got lots of people coming and going every day with lots of different disabilities and access needs. And we wanted the law to be able to create a more inclusive environment for them without them necessarily having to ask for a specific reasonable adjustment each time. So that's why we're including the concept of an anticipatory accessibility duty. Now, this duty is only going to apply to providers of goods and services, and that obviously includes the public sector, and to education providers. It isn't going to apply to employers. Employers will need to consider appropriate adjustments. And the idea behind the duty is that service providers will have to think about common needs that might arise and about how those needs can be met in advance. So that will include questions of physical accessibility, but also the way that information is provided, the way that staff are trained to serve customers with disabilities, and so on. And we're suggesting that the most straightforward way to respond to the duty will be to carry out an accessibility audit, so to do the thinking around what kind of changes might be needed to make your environment more inclusive, to develop an accessibility plan, which will set out what you're going to change and over what time period you're going to change and how, and then taking steps to implement that plan over a reasonable period of time. And again, it's important to stress we are not going to be expecting service providers to make changes that will be a disproportionate burden on them, so because they're too expensive or because they're not physically feasible. And it's not going to be a case of you've got to draw up an action plan and then boom, the next day everything's got to be perfect. It's about taking a series of steps so that your service, and because we hope everybody will be doing this, the whole island by extension, gradually becomes more inclusive for everyone. So it's about progressively realising that goal of inclusivity. So to summarise, appropriate adjustments are responses to individual needs within a specific context, but the anticipatory accessibility duty is about anticipating common needs and creating a more inclusive environment for everyone. We're proposing that the duty to provide appropriate adjustments, of course, will be enforced from the moment the law itself goes live, but we're recommending that the accessibility duty should be introduced more gradually. So at the moment, what we're suggesting in our consultation is that within 2 years after the law coming into force, you will have to have an accessibility action plan. So you'll have to work out what the access needs are and how you're going to meet them over the coming years. And we would expect people to start making changes to, say, information provision or the way they train their customers or those other kind of needs they might have identified in their plan as soon as you've got your plan in force. But physical changes to buildings and infrastructure, we're suggesting might need a 10-year lead-in period. So this is to allow small businesses especially, and we've got a really high number of small and micro businesses here in Guernsey, so we need to be conscious. We can't leave them out of the scope of this law because they are so widespread in Guernsey. That would just not result in the law making the desired changes. But we also know that we need to introduce the law in a constructive and manageable way that works for them. So it will be about allowing small businesses to plan for, to manage the possible practical and financial impact of the changes, and of course to give everyone a decent run-in period to get good advice and really think about the kind of changes that they need to make. But of course we will strongly encourage, and there won't be any penalties for people who want to start making physical changes sooner. So those are the key concepts that relate to how the law, we hope, will change things and will provide added protection, particularly for disabled islanders. But just one last concept from me before I hand you back to Michelle. We really think that it's important that this law addresses the pay gap and the general issue of lower pay in occupations that are commonly done by disadvantaged groups, which in this context includes women. And this is particularly relevant given that this state, and probably every state that came before us, has emphasised the importance of personal responsibility. And when you boil it down, personal responsibility in the mouth of a politician usually tends to mean you go out and earn a wage that will allow you to raise your family without depending on the states, and then you retire on your own resources and don't bother the states with your needs. So if that's what we mean by personal responsibility, fine. But at the moment, the decks are very consistently stacked against some people doing this as effectively as others. So we at least owe it to the population to try and create a more level playing field. So the first concept in respect of equal pay is that it would be unlawful for two people who are doing the same or a very similar job for the same employer to have different pay terms and conditions simply on the basis of a protected ground. So if you think, for example, about an employer who paid their male cleaners more than their female cleaners simply because they were men, that would not be okay in the context of this law. Now, of course, it wouldn't be discriminatory to pay people differently for reasons other than a protected ground. So things like length of service or your performance at your job or your seniority, that would continue to be fine. But as well as paying people equally for doing the same work or not discriminating between them on the basis of a protected ground, there is the concept of equal pay for equal work. And that goes a little bit further. Again, it's a fairly common concept in other non-discrimination laws, and it leads towards the achievement of the Convention on the Elimination of Discrimination Against Women, which Mish addressed at the start. But the idea here is that if two people are working for the same organisation and doing jobs which require a very similar level of skill or effort or responsibility, so that's the equal value bit. If you look at it objectively, the two jobs have equal value to the organisation, then those people should have equal pay. And again, this is relevant where the jobs are divided along the lines of a protected ground. So if you think, for example, of an organisation where most of their caretakers are men and most of their canteen staff are women, and your caretakers are consistently paid more than your canteen staff, but if you look at the jobs objectively, they require an equal level of skill and effort and responsibility. In that situation, there may be a case for an equal pay claim. So going back to our consultation, we're asking about the rate at which some parts of the law ought to come into force. And we recognise that the anticipatory accessibility duty and the concept of equal pay for equal value might require more forward planning by employers and service providers than most other parts of the law. So in the case of the accessibility duty, service providers might want to carry out accessibility audits and develop their own plans, while in the case of equal pay for work of equal value, employers might want to use a job evaluation tool to make sure there's an objective relationship between pay, skills and responsibility across their staff groups. So bearing in mind the added complexity of those two areas, we think that there might need to be a lead-in period once the law has been introduced before those two provisions come into effect. So if you're responding to our consultation, we've got a particular question about that, asking you to let us know what you think. And of course, we're also asking, are there any other parts of the law that might need a longer lead-in period? And on the flip side, are there parts of the law where there's an urgent need to bring them into effect perhaps sooner than the committee was anticipating? So, let us know either way. Those questions are in our consultation survey, and we would really welcome your feedback. So hopefully that explains some of the core concepts that structure our non-discrimination law. I'll just move the block back into place before I move, and I'm going to hand back to Mish to explain how people are going to use the law in practice to seek changes.
Thanks, Em. We didn't want to have an accident and then worry about health and safety, which is also part of our mandate. Right, I'm going to go on and talk about the complaints process. So we propose the structure of the complaints process will be based on the existing framework in place for sex discrimination complaints with some tweaks. So we know the majority of discrimination complaints can be resolved informally, and we don't really want people going through a legal process, and most people actually just want to have their issue resolved. So we're suggesting that people should first raise their complaint with the employer or service provider that they feel has discriminated against them. This will provide the employer or service provider with the opportunity to put the issue right. And we're also saying that free advice will be available for the complainant and the employer as service provider, and we're anticipating that that would be through the Equality and Rights Organisation. But if the issue isn't resolved, a person will be able to register a complaint with the Secretary to the Employment and Discrimination Tribunal. Conciliation is an important part of this process, and conciliation will be offered to both parties, as currently the case in sex discrimination complaints. And conciliation is carried out by a trained person, and we know it can be a very effective way of helping people to resolve disputes informally and without going through any further processes. Participation, of course, would be voluntary. But, you know, conciliation doesn't always work, and if it doesn't resolve the issue, the case will be heard by the new Employment and Discrimination Tribunal. So currently the tribunal is a panel of 3 lay people drawn from a wider panel of members. And the tribunal currently hears sex discrimination cases. So they've got experience in sex discrimination field, but we know some changes are going to have to be made, and we're going to need to widen the experience and the capacity and provide some training and support for this tribunal to hear the cases under the new legislation. But we're still working on how that will look. Parties will be able to appeal the decision within 1 month to the Royal Court, but just on a point of law. And we're saying that this process will be open to both parties. At the present time, people can represent themselves, or they can nominate someone to represent them, such as a friend or trade union. So we're hoping again to follow the same sort of guidelines and say that it would not be essential for you to have to appoint a lawyer to bring the case forward to the tribunal. So, awards and remedies, and if you've been listening to BBC Radio Guernsey today, you've probably heard some of the conversation about awards and remedies. And at the present time, the maximum award in a sex discrimination case is 3 months' pay. And actually, from the feedback that we've had over the last few months, we actually realise that this puts off a lot of people putting their head above the parapet and actually bringing forward a case, because their names usually appear in the media and on social media, and then they often find it very difficult to go back into that employment or to find an alternative work. So we are proposing that in future financial compensation should be proportionate, and I'm emphasising that, proportionate, and should be based on the actual financial loss someone has experienced. And I think this has been the contentious issue that's been in the media today. And we're also saying we're looking at an additional payment, and that is an award for injury to feelings. And injury to feelings is a payment that is made in other jurisdictions. It's paid in the UK, and it's based on what is called the Vento scale. And it has 3 bands, lower, middle and upper. And the lower band, I think the maximum is something like £4,400. And again, the upper is £44,000. But the higher limit would be only in exceptional cases. And we're talking about cases of discrimination, harassment and victimisation that can often cause great mental distress, humiliation and anxiety. So that is what we are proposing, and we're asking through the consultation process for you to think about whether there should be an upper limit on both of those, an upper limit on the financial compensation and an upper limit on injury to feelings. We also think that it's important that people seek remedial action, so it's not necessarily about the financial remedy or financial compensation, but it's non-financial remedies. So we would be looking to address the cause of discrimination and wanting to put things right. So we would be looking to include an order for equal treatment, an order for specific course of action that the employer or the service provider might have to take, a reinstatement. If someone was employed, we might order that their employment needs to be reinstated, or a re-engagement. So again, really important that we receive your feedback on that particular question. And that one is just really, that slide is just going through what I've already said. The Equality and Rights Organisation. So 2013, the states approved in principle the equality of an Equality and Rights Organisation. But that was subject to the development and approval of a business plan and to have funding in place. So the committee for ESS committee is currently preparing the business plan in liaison with various stakeholders. And we would expect that the ERO would have quite a wide range of functions. And we've got a list there. What might an Equality and Rights Organisation do? And again, I'll read that out for people that are at home. Education and awareness raising, advice about equality and human rights, issuing codes of practice, research and monitoring of equality and human rights issues. And that, again, is really important because very often we've come up against people saying, well, there's no need, there's no discrimination in Guernsey, because actually we've got very little evidence so far. We're grateful to organisations such as the Citizens Advice because they've already collected some limited data, and that is helping us, but it's really important that we have the data going forward. And there are also broader functions that the ERO, in relation to human rights, we would want them to carry out, and also to support people to bring cases. So one of our key questions is saying what would be important for us to include in the mandate of the Equality and Rights Organisation. And we will require that information because we need to prepare our business plan and put that to the States of Guernsey. So, finally, the consultation. So this is your opportunity to have your say and shape the legislation. All too often, we get to the States and we bring a policy paper, and it's only when we've approved that policy paper and the Guernsey press and the radio and the media cover that the following day that people actually realise that it affects them, and they realise that perhaps they should have spoken up sooner. So this is your opportunity now, and I encourage all of you to participate. It is relevant to everyone. The committee has not made up its mind on the way forward, so we really do need your input on this. Now, the consultation is open till the 30th of September, and we've issued a huge variety of documents. So we've got a technical document, which is about 180 pages, and we're really expecting our stakeholders and people really interested in such as employment legislation, etc., that they will probably take the time to read that. But we've got a summary proposal document, and we've also got a questionnaire. We've got a frequently asked questions document. We've got an easy read version because we appreciate we've taken probably 45 minutes to go through the presentation this evening. There's quite a lot in there, and not everybody will want to read through that. So we've got an easy read version, and we've got various alternative formats. We've got the Guernsey Blind Association, who've got an audio format for people that might need that. But if you have got any requirements and they're not met by the existing documentation, please contact us and we'll be happy to help. We've also issued the consultation in 3 different languages as well. So, as I say, please respond by 30th of September. The details are on the website, and we have got a few copies of various documents that if you come and see us at the end, we'll be able to give those out to you. Just to remind people of the timeline, so once we've got the consultation feedback, we will then go through that feedback and prepare a policy paper that we hope to bring to the States by April 2020. And once that is approved, we hope the legislation will come back for approval in 2021. So we'll go on to discussion and questions. But before I do, because I know I'll forget at the end, I just want to take time to say a huge thank you to all the people that have contributed, all our stakeholders, but in particular the staff at Employment and Social Security. They've put in a huge amount of work. They're here again this evening. We've done, I think this is our 5th or 6th presentation. And I just wanted to say publicly a huge thank you to those people, because without them, we wouldn't have progressed as far as we've already progressed. Perhaps not as quick as some people wanted, but we wouldn't be here today without them. So thank you very much. And if Shane wants to come up and join us, we're very happy to take your questions. We've got a question at the front here. Can we just wait for the microphone? So, yes. Well, it's just so that people that are...
Thank you. Is it on? Oh, great. Can I add my thanks to all involved? I think it'd be a great legacy to your committee this week. Some of us have waited for this. If I recall, I think the UK introduced an Equal Pay Act in 1971. But if you'll bear with me just for a minute or two, I haven't read the whole document, so I have to confess that, but I will do, I promise you, and I will send some comments. However, my interest was drawn particularly to the issue of equal pay, being a bugbear of mine for many, many years. Can I just give you a little story about the NHS for an equal pay claim? And this was about 20 years ago. And there's a speech and language therapist that wanted to compare her job with a psychologist she was working alongside. She took it, as you mentioned in your process, to her employer. Employer ignored it. So her professional representation and her professional organisation took it to Europe, and they upheld her case. The NHS immediately knew it could be bankrupted by equal pay claims. So what they did, they got all the unions together, all the people that were represented in the NHS, and they agreed to introduce a job evaluation scheme. And that job evaluation scheme was about 5 years in the development, and I was involved in that. And bearing in mind, the NHS is probably one of the biggest employers in the United Kingdom. And they developed this job evaluation scheme, and it covers every single occupation and professional group within the NHS. There's a national profile for every single person, except doctors, but we won't go there. Guernsey introduced Agenda for Change for its nursing staff only. And we were able to, I was responsible for the implementation of Agenda for Change, and that was grading and job matching 1,000 nurses and midwives' jobs. What we did afterwards, very interestingly, we took a number of other job descriptions. This was purely an exercise. We took a number of other job descriptions that are employed by the then Board of Health, psychologists, speech and language therapists, finance officers, porters and all, and we job matched those. And then we looked at the salary scale they should be on Agenda for Change. And not surprisingly, every single one of those were paid much, much higher in Guernsey than they were in the UK. So where I'm going with this is it could lead to massive pay claims in Guernsey. And my biggest worry is that when it is presented to the States, whether they will reject it. Everyone will know it's the right and proper thing to do, but they could reject it on the basis that they couldn't afford it. I'm sorry that was fairly lengthy, but equal pay for me has been a passion for a long, long time. It's just your comments on that, whether it'll be thrown out because they'll feel that they can't afford it.
Well, I think we've already been approached at one of the stakeholder meetings, and we know that we have to have a meeting with the States of Guernsey. over this, and for exactly the same reasons that you've laid out. I guess in some ways it was easier in the UK because the NHS were a separate employer, whereas here nurses are actually paid through the states of Guernsey, so that probably adds another complication to that. But it is something that we know that we are going to face. I think it was part of the reason that Em said again that there is a phasing in. I would hope that it isn't thrown out, but then there may need to be some discussions about phasing in. I would be concerned that we give preferential treatment to the states of Guernsey and the public sector and not to the private sector. So I wouldn't want us to be going down that route. But those are concerns that we have, and I don't know whether anybody else has got any comments. Shane?
Only that I think Sandra's right, that everybody's going to want to know what the financial implications of equal pay are. And I think that's been considered in the past. It might be the reason that CEDAW, which Mish mentioned, the Convention against for the elimination of discrimination against women, probably hasn't been adopted in Guernsey as quickly as it might have been because of the implications, the financial implications. So it's going to be complicated, but and I can't guess whether the states will approve it or not. But they're certainly going to want to have an reasonably accurate set of figures to make the judgment on.
And as Michelle knows, I don't always speak the committee line, and anything I say shouldn't be seen as representative of the board. But I tend to think it's a conversation the states need to have, because we know that we have a very complicated employment structure at the moment, a bit unsatisfactory, with policy and resources doing negotiations for people who work in the health structure. But we would also say we have definitely high costs on Guernsey. We need to retain and motivate more local employees in the health professions. At the same time, we need something beyond the gender for change. We need recruitment, retention, and long-term career structures, and maybe one of the roadblocks in the way is not just the pay structure, but the anomalies that may exist, and the sense that certain professionals of various genders or situations aren't getting the appropriate rate for the job. So that's a conversation that probably the next states will have to have, but it goes beyond this, and I think we're focused on the principles at the moment.
Okay,
That's all right.
Okay, and the lady, thank you, Sandra. The lady behind Sandra, thank you.
Hi, my question is about Part A, Section 4 of the multi-ground discrimination legislation draft proposals. I note that the committee is proposing a choice between three definitions of the word sex, which I think most people will be bewildered by, to say the least. I think it's clear to everybody what sex is. It's the biological state of being a man or a woman. The World Health Organization defines sex as the different biological and physiological characteristics such as reproductive organs and chromosomes. So my question is, given that we read in the notes that the committee is divided on this issue, why does the committee think they can disregard all of this biological, scientific fact and just make up their own definitions?
Well, firstly, I'd say that we're not making up our own definitions. These are definitions that are terms that are in use already.
You seem to be conflating sex and gender. Sex is a biological fact.
Well, this is an area where there will be polar opposite views. And it's an area where, as we've already said, the committee have got different views. And that is why we are seeking, through this consultation, the different views of different sectors of our community. So you believe in biological, but there are other members of our community that have a different view to that. So.
Yes, so they can have their beliefs, sure, but they can't have their own biological facts.
well, we have to find a way forward. Did you want to comment on this?
Well, only to encourage you to read more widely in terms of what the World Health Organization has put out in respect of the definitions of sex and gender.
But
Shane?
gender is a social construct.
Shane, did you want to?
Yeah, as you might have as you noted, it was a majority decision by the committee. Well, I was the minority. I tend to agree with the speaker, but I don't think the committee just ignored that. I think option B, which is the committee's preferred option, was an attempt to moderate option C. Personally, I don't think it succeeded, but I think sort of caring liberal people are looking for, in fact craving, a compromise, and that's what drove the option B. Personally, I think there's too many contradictions in option B, and that the risk is it's going to prove to be unworkable, and we will by default end up with option C. And option C gives everybody the legal right, basically, to choose what sex that they want. And that has an inherent problem, which I'm sure everybody's aware of. That means that male-bodied individuals will be able to compete in women's sporting events, and they'll be able to access women-only spaces and services. And option B tries to, as I said, moderate that by introducing two concepts. Firstly, it says that the tribunal can overrule, in exceptional circumstances, a person's decision about which sex they're going to choose. But the court or the tribunal isn't given any definition of what a man or a woman is. So how the court is going to make a judgment when there's no definition, it's beyond me. And the second idea that option B comes up with is to put the onus on the service providers or the sports organisers to objectively justify excluding somebody from the activities or the spaces. And I think that's going to be almost impossible to do, because if you've said somebody's got the legal right to choose whether they're a man or a woman, how do you objectively justify excluding that person from, for instance, a women's half marathon or something like that, or a women's changing room?
It's self-ID by stealth.
So I think option B's. I can understand why the majority of the committee came up with option B, but I think it's hopelessly flawed, personally. I agree with you. I think it sounds mechanistic, just to use biological determination as to one's sex, but I think that's the only really viable way to do it.
Okay.
I think it's just relevant to point out that, of course, option B reflects the position in the current law. Our law, like a number of other non-discrimination laws, defines sex as being a man or a woman, without going any further into the question of gender or the question of biology. And my commitment from the start of this project was to make sure that, at the very least, we didn't roll back the existing protections that are in place in Guernsey. So that, Shane, having set out the minority position, that I think is where the majority view comes from.
Yeah. But we're told we've got this unique opportunity in Guernsey to write this wonderful Equal Rights Act. So why don't we just get the definitions right to start with?
Well, that's what the consultation is about, to get the definitions right and to receive the feedback. And as I said, there will be completely opposing views to your own views. So that is where the difficulty comes. And I expect when we bring a policy paper to the States, we will have to make a decision. And then ultimately it will be the States to decide, but at least with all the facts in front of them and with the consultation process as well.
But unfortunately, in the consultation, you conflate sex and gender several times. So it's going to be hard for any member of the public to know exactly what you're talking about.
Well, but we've got a free format questionnaire so that you can just put your views in that free format questionnaire.
Well, I hope everybody does take the opportunity to do that. Thank you very much.
I mean, I'm a bit in between on the issue, really. You've heard two very different perspectives. we will have, and we have had certain legal advice. We've had advice from academics, we've had advice from lobbyists and people who are very informed on these questions. We're looking at international examples. And clearly, in my own life, I've certainly known a brave and courageous person who's gone from one gender to another via the biological route. There's that kind of person. There are also people who, for different reasons, might choose to adopt a different gender. Now, it seems common sense to me that if someone has gone through a psychological and physiological medical transformation, that person has changed their sex. Effectively, even if they were born a different sex. We could also argue that there have been cases of children around the world who've been born in an indeterminate way. So I kind of want to know more before I make my mind up. And you, everybody here and beyond, can give us your feedback and viewpoints.
Okay, thank you. Have we got any more questions? Yeah. And then we'll go to one of the questions from the online afterwards.
Hi. Some other nations in the world, like Pakistan, have officially recognised third genders. I wonder if that's anything that would be on the table that the states are considering, which is official and is all this documentation and IDs.
St Paul used to talk about.
I don't think we have we?
It's not something that we're proposing at present, and I think sort of culturally in Pakistan there is more of a recognition of three genders than there has been culturally in Guernsey. But if that is something that you want to feed into the consultation process, then we would welcome your input.
Thank you. And I think we've got a question. Thank you, Sarah.
There are two questions that have come in on the live stream. The first one says, given the length of time it has taken between an identified need and it taking effect, will consideration be given to cases that have occurred post-2013 but prior to the finalisation of the law coming into force?
No, I don't think that this will be retrospectively, because we've actually put in the consultation document that there's a timeline that the discrimination, you can only bring a case within 1 year of that discrimination. So it is unlikely that we would go back beyond the date that the legislation is implemented.
And the other one says, who will lead this if you're no longer elected deputies after June 2020? Thank you.
Well, it will still be part of the mandate of employment and social security. And that's why the committee feels it's really important that we get our policy paper to the states in this political term, and that there is clear guidelines for the legislation drafting. And just to say that we've had very close work already with law officers. They're unable to draft the legislation at the same time as bringing in the policy paper, because we know that the states may change some of what they want in the final legislation. But it will be in train, and hopefully the next committee will be as passionate about bringing this work and getting this work through and over the line in 2021 as we have been, and it will remain a priority in the policy and resource plan. And I don't know if any of the other committee want to comment on that. Shane?
I was going to say trust the states, perhaps. This is such a powerful proposal and piece of legislation. It's so embedded in the policy and resource plan. I can't see there being any problems it moving forwards in the new states, even if none of us happen to be on that on that committee.
But Shane, in a way, I could come back on you there. You say trust the states. Actually, you've got to
slightly tongue-in-cheek.
You've actually got to trust the people, because we are, rightly or wrongly, going into this rather bizarre but challenging new electoral system next year, where there could be an infinite number of candidates for 38 seats. Now, the point is, people who care about discrimination, the legislation, equalities, disabled access, liberation legislation, they all should not only communicate their views to candidates, but consider proposing, seconding, or being candidates yourself, because the power behind implementing this will be very much part of the new Assembly's life as well as this one.
Yes, well, I suppose the
That's
point...
not a plug, but...
Well, no, I mean, the point to whomever asked the question, and to anybody who's thinking, well, how is this going to carry on? If you feel able to be part of helping it to carry on, then please do.
In one way or another.
The other thing to bring up is that Mish mentioned in her slides that we are hoping to develop an equality and rights organisation, and that will be an absolutely key part of making this law effective and constructive and user-friendly, actually making the practical differences in the community by providing advice and support and training. And it's something that we want to get up and running before the law is switched on, so that employers and service providers and others who are going to be affected by the law can hit the ground running. They're already doing things right because they've had the support to do things right. So that's something we're going to be asking the states to do before the end of this term. And I think that if we can get that in place, and it will be really important, again, to if you think it's as important as we do, to bring your voices to bear on the states to say, look, this is something that the island needs. That having an equality and rights organisation in place is going to start creating the environment that the law is then going to provide the framework and the backstop around. So if we can get that in place before the end of this state's term, hopefully we'll begin to see the benefits even before the next states come into seat.
Yeah, thank you. Mike? I think it's just we need it so the people for the live streaming can hear, Mike. Thank you.
On the video tech.
1, 2, yes. My biggest worry, and hopefully it doesn't come to fruition, is that all 4 of you may not be in the States after next June. So hopefully the work that you're going to get done between now and when you bring it to the States in April or whenever, is that it's sufficiently strong enough so that any new parties can't just turn the whole thing over, which we've seen many times before. Because you've put such a lot of work into this, and I wouldn't like to see it destroyed because of a new bunch of people that didn't agree with what you're proposing.
Well, I think, Mike, Mike is an ex-States Deputy, that once the policy paper has been brought to the Assembly and once that resolutions have been agreed, then that is more difficult to overturn. We do see that occasionally. So that is why it's the critical piece of work to get. And I know some people are probably a little bit critical about the consultation period and it being through the summer holiday, etc. But we needed to get this out and get the feedback so that we can crack on with the policy paper. And, we've got a great team. We're putting our resources in. So the key is to get that policy paper and those resolutions approved. And I think because we're hearing tonight and we've heard in previous feedback that actually there are some controversial parts. And I think for me, I don't want this to be completely derailed by bringing just 1 or 2 resolutions. I think we're going to have to bring several resolutions so that we can vote on certain parts. It would not be ideal. I'd rather that we get all the resolutions passed to bring everything in. But I don't want it to fail, and I don't want to let down particularly the people that have, lobbied for the disability strategy. I don't want that to be lost in some of the other more perhaps controversial elements. So I think it's how we write that policy paper, and it's key that we get it over the line in this political term.
Good for you. You obviously know your states.
It's true that, though, because I get carried away, I'm afraid, like a mini Donald Trump during the Twitter polls, the Twitter troll or whatever, because there are characters around who like to stimulate debate on Facebook, on Twitter, on Guernsey Press websites, Bailiwick Express, and sometimes one can react to them. But the real truth is that although we're passionate about this, we're also impartial in that we're awaiting public response. And it's probable that when we get the feedback, all in a way, we will listen to it. We will also have our own convictions, and another one of our members is Deputy Roppy, and he's not short of political principles and so on. But we will then go to the States with a considered package, and frankly, there probably will be some amendments to it put by other members. There's a chance 1 or 2 of them will win. But the bare bones of this should be meaningful by next Easter.
Yes. Okay. Yes, another question at the back.
I'm sure you've looked. I haven't looked at the document, to be fair. You mentioned about equal pay. What will be done about men getting, because obviously there's a lot of research and studies and things like that, men earning higher because they're in higher positions, because they're men, and women in lower positions because they might work part-time to look after the children and things like that. What's being done about that exactly, that inequality in the workplace where men are going up into higher positions than women?
So I think some of that is structural, and it goes beyond what discrimination law alone can achieve. So if you think about things like provisions for parental leave and the fact that there isn't much provision for men to support their partners if they're having a baby, so the whole context around why it's cost of childcare. That was the other thing that I wanted to bring up. Cost of childcare in Guernsey again discourages one parent from going back to the workplace often, and if you've got a circumstance where, as you already described it, women tend to be in lower paying jobs than men, then that's often the woman. All these structural factors reinforce and create a sort of loop of disadvantage. We will challenge or discrimination law will provide for people to challenge where they can, but I think there needs to be a conversation with the states about the wider policy framework, so about things like parental leave and the cost of childcare and what it means to raise a family in Guernsey, that will deal with some of those structural disadvantages that at the moment particularly affect women in the workplace.
Thank you.
Can I just say, as Emma's right, there's no way this legislation would be a panacea for the problem you identified, but it's certainly a step in the right direction in addressing things like the interruption of career progression due to caring, and obviously caring is one of the grounds in the legislation. So I think this is probably a bigger step than one might first imagine towards a more equal situation.
Okay. Yes, a question at the back. Okay. Oh, sorry. Go to the back and then to this gentleman. Sorry, apologise.
Thank you. I was just wondering, do you see it being the responsibility of the ERO to monitor the accessibility duty implementation from organisations and service providers?
That's a good question.
I think we do. Yes, we haven't quite scoped out the full business plan for the ERO and what it would cover, but that would make sense for the ERO to take on that responsibility.
Yeah, and so is there a plan B for if the ERO isn't created?
Well, if the ERO isn't created, I'm not really sure what we can do, because we would then implement the legislation, but we would have no organisation or tribunal.
Yeah, it feels like it would just undermine the whole.
Yeah, so the ERO is something that we have said for a long time is a key part of this. The ERO could actually function without the need of the legislation, but we're greedy, we want both. But it is a key part of it, and I don't see how we can really progress further if we haven't actually got the means of a complaint system, where to go for advice and education, particularly if you've got a small business. Small businesses will need that ERO to get that information. Now, there may be other organisations, and Paul is here from Citizens Advice, but, they've got enough to do. So it wouldn't be fair to rely on some of those other third sector organisations. I think it would become quite bitty. Having one central place to go, I think, is really key to the success of this.
Michelle's right, because although we've had splendid enthusiasm from policy and resources in helping us both politically and with an excellent staff resource, I think policy and resources and the whole state needs to be aware that there is a budgetary cost for an ERO, and that should be decided by the end of this term and set in place. And there are other ways it could be done, but they wouldn't be so good, because it would rely on voluntary organisations out there calling issues out, or raising money through crowdfunding or something, or I don't know. We currently, of course, and have had for many years, various metamorphosis of the disability officer and the disability officer's role, along with the political disabled people's champion, was to look at these things. But they didn't necessarily have the clout or the resources of an ERO. So the ERO is actually the ERO is essential for us to sign these various international treaties as well. It goes beyond having the law in place, and so we do need to see that happening.
Did you want to comment?
Well, just to say that we want the introduction of the law to be as positive as the introduction of a law ever can be. So if anyone here was at the Equality Conference last week, you will have heard local employers who already think about diversity and inclusion talking about just how beneficial equality in the workplace and in the provision of goods and services can be. So there are benefits to be gained from that law, but they can really only be realised if we introduce it in a constructive way. So if you don't just have it as a stick to beat people over the head with if they get things wrong, if you're thinking up front about, well, how do we help people to get this right? And that's where the Equality and Rights Organisation is so critical in creating a positive environment for change. So, yeah.
And maybe some money as well to help small businesses adapt.
Yeah. The gentleman here, I apologise. The lights are blinding.
Thank you. And thank you for a wonderful presentation. I wonder if you could just help me understand, if you have a tribunal in place, who defines and decides what is appropriate, disproportionate, or reasonable in the context of this legislation?
Those were in the case where, in the instance where a case comes to a tribunal, those are the kind of judgments that you would expect a tribunal to be making. Now, one of the reasons why we wanted to build our law on model legislation from another jurisdiction rather than just reinventing the wheel from scratch in Guernsey was so that our tribunal wouldn't be operating in a vacuum, so that they would have the case law and the expertise of practitioners in other jurisdictions to draw on. So we've built our proposals mainly around the Irish and Australian law. We've drawn a bit on the UK. So depending on which bit of the law a person was taking a case in relation to, there would be expertise and case law out there to guide our local tribunal. And we're also conscious that we need to underpin that by training, by expanding the membership of the tribunal to make sure that there is proper expertise across the breadth of this law. So the answer in short is the tribunal, but the longer answer is in the context of an environment of support and training and case law from other areas that has already established principles around appropriateness and reasonableness and so on.
And we've already been in conversation with the Sex Discrimination Tribunal, and they're very much sort of helping us in formulating what the tribunal will look like. And one of the essentials that they've said is that they will need some legal advice as well. So that will be, again, part of our business plan will be to ensure that they have proper legal advice, giving advice to the tribunal, which they haven't got at the moment. Okay. Have we got any more questions from live streaming, Sarah?
Yeah, we have got a few more. One of them talks about the definition of disability, point B, and suggests that a person affected by cancer is classed as disabled when cancer is present in their bodies. I think they're talking about the definition in the consultation document. It says, in the UK, from the point of diagnosis, you're protected by the Disability Act for the rest of your life, even when cancer is no longer present in your body after treatment. Will that be the case in Guernsey?
I think that's what we're saying, aren't we?
Well, certainly, while the I think so, yes. I think that is how you would read Part B, but perhaps if that's a live stream question, it's out there, we'll get a full response back to them on that point.
Yeah.
Now, I'd have to think about the ramifications of that, but the principle that I tend to go with is a more social model of defining disability, and that gets away from the argument of are you sick or not, which can certainly be an issue with certain behavioural conditions, cognitive issues, mental conditions and so on. And it's very much of an adaptation model, and it tries not to get too much into the issue, is he or she disabled or not. It's actually looking at the impact of the condition on an individual's life and potential, and society around them. So
I think on that particular question, what we'll do is if we can take the details of the person contact us, and then we can get some legal advice and specific advice on that one, Sarah.
Yeah, definitely.
Okay, and another one deals with what mechanisms do you anticipate putting in place to deal with potential clashes of rights?
Ooh, clashes of laws.
Clashes of rights.
Sort of between different characteristics.
Well, again, that would be the tribunal to give, well, the ERO initially to give some guidance and advice, and then for the tribunal to determine.
I think this, yeah, and I think this also might be, rather than specific cases of right clashing, this might be where the framework of the law, and particularly the exceptions, might say, well, you know, the exceptions are there to say there are sometimes legitimate reasons why you might treat people differently, even on the basis of protected grounds. So I think that is one of the principal mechanisms for dealing with it.
But also, I think one of the reasons that we wanted to bring the more encompassing legislation is that experience has found that if you bring discrimination on just one ground, you can often fail, but you could bring the discrimination on another protected ground. So again, that's why it's been really key for us to bring in the multiple protected grounds rather than just one or two protected grounds.
I mean, yeah. Can I just finish?
Yes, certainly.
Em talked about some exceptions. I think she's right. I think rather than a clash between rights, I think you're more likely to get a clash between a right and the exceptions relating to another right. I think that's probably where, if there is any conflict, that's where it would arise, rather than between rights themselves.
Okay. Have we got any more questions? Okay. Oh yeah, another question. Get poked with this thing.
Sorry, just to add on to that last point, I think what that live stream is talking about is intersectionality. So when there's certain characteristics, so for example, when that was brought about where there was black women being discriminated, and when they looked at the case of black people in the organisation, they weren't being discriminated and women weren't being discriminated, but black women were being discriminated. So I just wanted to add that.
So when we were designing, the first step in designing the law was to find our model legislation that we wanted to base it off. And so as a committee, we came up with a series of principles that the model law needed to meet. And one of those was helping us to achieve the UN conventions, particularly the UN Convention on the Rights of Persons with Disabilities. And one of the key points in that is exactly what you've just said about intersectionality, that non-discrimination law should reflect effectively the complex realities of people's lives, that you're not just a person with a disability, you may also be a woman, you may also, you're from a different nationality, so having a law that is capable of coping with intersectionality. So that was one of the things that we have taken into account at every stage of developing these proposals.
Yes, Emily's given you a brilliant academic answer, but I'd say that also was our thinking, because some of the people have in a more simple way said, why is it you started out with the Disability Alliance calling for a framework for disability, and it's expanded to cover a much wider range of rights and equalities? Well, it is the intersectionality that makes the difference, because it effectively, sometimes people, even in Guernsey, if they might have disabilities, but if they're from certain ethnic groups or in a job that's not paying equal pay, for example, because of a structural gender issue, or there might be other factors there about their sexuality or about perhaps even their religious beliefs. So you have to look at the whole package. And I think that's why, from a Guernsey point of view, given that we haven't got infinite resources and infinite opportunities for commissions, that's why we're doing the whole lot together.
Okay. Have we got any more questions? No? Well, thank you very much for attending this evening. We really appreciate you coming here. We'd appreciate even more if you complete the consultation questionnaire. we'll be around for the next 5 or 10 minutes. So if there was a question and you didn't want to ask in public, please come up and ask us. And for those where we perhaps been a little bit unclear on the answer, we'll make sure we come back to people on that. But again, thank you very, very much, and please go ahead and complete the questionnaire. Details up there, and we've got some hard copies here. So thank you again for your time.